Thank you. Thank you very much. I want to thank again Shane Patterson for the opening and the prayer, and I will try and heed his words with what I say today. I want to thank Deborah Parks for the invitation. It's nice to be able to come back to Winnipeg. It's 20 years since the AJI report. I recall the AJI report because I was at an Aboriginal Justice Conference, there are a lot of them, in Whitehorse, and it was 3 or 4 days, and in the middle of the 3 or 4 days, the AJI report was released, and they flew a bunch up, and they put them in the back of the auditorium, and they'd arrived, and someone was presenting, and we were all like going, okay, what do I have to do? Do I have to listen to this presentation, which we really should, or do I run to the back to get my copy of the AJI before they all get taken away? So I did restrain myself, went to the back, and I keep my copy of the AJI and refer to it regularly, and in fact was looking at it just earlier this week. What I want to start talking about, and Deborah asked me to talk about, is you heard about the Gladu court. There's now 3 Gladu courts in Toronto. And one question people ask is, why Toronto? Why is there a Gladu court in Toronto? You would think if you were going to establish a court for Aboriginal people somewhere in Canada, Toronto wouldn't be the first choice. So I want to talk about that a bit. First of all, though, you should know that Toronto actually has perhaps the largest Aboriginal population in Canada. The latest estimate is about 86,000 people, Aboriginal people, live in Toronto in the GTA. So it's a very large population. But it's 86,000 out of a population of 2.5 million. There's no particular Aboriginal community, Aboriginal part of town. The Aboriginal community is within Toronto largely invisible. Another thing, though, just to keep in mind is people were talking about overrepresentation. The rate of overrepresentation of Aboriginal people in Ontario is the same rate of overrepresentation as in Manitoba. The difference is Aboriginal people make up about 2% of the population in Ontario, so they make up about 10% of the provincial jail population. But the rate of overrepresentation, which is over 5 times the population, is the same as Manitoba. So we shouldn't blind ourselves, and it's a big concern in Ontario because people tend to be smug and self-satisfied, that it's not a problem. And speaking of being smug and self-satisfied, I also do want to say that I'm going to be talking, obviously what I'm going to talk about is relevant to Toronto and my experience. In no way am I going to sort of tell you what you should do. I know how eager you are to have people from Toronto come out west and tell people what to do, but I'm going to resist that as much as you ask me. I'm going to try and fight that feeling. So the reason that ALST became involved in the Gladu court starts with the Gladu decision itself. Aboriginal Legal Services was the only Aboriginal organization that was an intervener in the Gladu court case at the Supreme Court of Canada. Our legal team consisted of 3 people. Professor Kent Roach from U of T, who's been a great friend of ALST and who argued the case for us. Kim Murray, who was our executive director and is now the executive director of the Truth and Reconciliation Commission, and me. So Kent and Kim were gowned at the Supreme Court, and I was in the little body of the Supreme Court at the back doing the wave when we came. And if you've never been to the Supreme Court of Canada, they don't like you doing the wave. So you can take with you. When the Gladu decision came out in April 1999, it was frankly a remarkable day. Speaking as a lawyer, right? What happened that day when that decision came down was why I went to law school. This was a decision, an incredibly groundbreaking decision. The language in that decision, I frankly never expected to hear from a court. To hear the Supreme Court of Canada call the overrepresentation of Aboriginal people a crisis in the Canadian criminal justice system. To, as Deborah pointed out, to say that jail doesn't work for Aboriginal people. The language in that decision was amazing. And so that was a very exciting moment In fact, it was an exciting few days. The Indigenous Bar Association was meeting in Toronto that weekend. I think the decision came out on a Thursday or a Friday. It was, by the way, a front page decision. The Globe and Mail had it as the front page, top of the newspaper. Canada's justice system fails Aboriginal people. Kim and I went to the IBA, and we were pretty cool, right? Because I mean, we were involved in this case. None of the other people at the IBA had been there, and we'd been there, and so it was pretty neat. And one of the advantages we have at Aboriginal Legal Services is we have a wide range of services. We have Aboriginal court workers, we have an Aboriginal justice program. So we get to see what happens with cases we're involved in. And so Monday comes, Gladue's out the week before, Monday comes, and I'm ready for the world to change. And the world didn't change. Everything stayed the same. It was staggering in some ways to see how little changed. You get a decision from the Supreme Court of Canada, you think, hey, they've told you what to do, and it was like it didn't happen. And literally, it was like it didn't happen. We would get calls from people who were across Ontario, and they'd say, you know, I'm going to court, and my lawyer doesn't know what Gladu is. What should I do? And we're telling people, just say the word Gladu from the box, and hope someone understands. We had a case where the only person who knew what Gladu meant was the Crown, who ended up arguing Gladu because the judge really wasn't familiar, defense counsel wasn't familiar. And this was true across Ontario. It was true across Canada. Supreme Court of Canada comes out with this incredibly significant decision, and nothing happens. Nothing happens. So about a year later, in 2000, September 2000, we were at a conference of provincial court judges. We were invited to talk about urban Aboriginal people. And we were talking about these issues, and one of the themes at the conference was Gladu. And there was an overarching theme for many of the judges who were at this conference, that they had this decision from the Supreme Court telling them they had to do something different, and they had no idea how to do something different. You know, as was pointed out in the first session, David pointed out, I think, Gladu tells judges to do something differently, but doesn't tell them how to do it differently. It tells lawyers and crowns to do things differently, but doesn't tell them how to do it differently. Why would we necessarily expect people who, with the best of intentions often, were involved in the overrepresentation of Aboriginal people? How was it all going to change on May 1st, 1999, after the decision came out? And so the judges were struggling with this as well. So we did this panel, and at the end of the panel, we talked about how disappointed we were that things hadn't changed in terms of Gladu. And at the end of the panel, Justice Patrick Shepherd, who's one of the judges at the Old City Hall Courts in Toronto, came up and said, why don't we talk about setting up a court for Aboriginal people where we'll get all the resources together, and maybe we can start to do things differently. And obviously thought it was a great idea, and so we worked with Justice Shepherd, and a year later, in October or November, I think November 2001, the first Gladu court opened at Old City Hall. It opened initially 2 afternoons a week. It now sits 2 full days a week. There's a Gladu court at the College Park courts in Toronto 1 day a week, and at 1000 Finch Court a half day a week. And it was remarkable. It was remarkable because we didn't go anywhere. If judges want to set up a court, this is something I learned, it was very interesting. If judges want to set up a court, they set up a court. They don't write funding proposals. They don't ask people for permission. The Gladu court was set up in Toronto at the same time as the Mike Harris government was going on in Ontario. I don't know if you know about Mike Harris. It was not, from my perspective, a dark shadow fell across the land for about 8 years. And certainly, even if there were people in the Ministry of the Attorney General who had been sympathetic to the idea, there is no way that the provincial government would have said, oh yeah, this is a great idea. But if judges say they want to set up a court, they set up a court. They talk to their local administrative judge. They talk to their senior regional judge. Yeah, we're going to set up a court. And they set up a court. The Crowns want to play? fine. But they don't have a choice, really, because if there's a court, there's going to be a crown. You don't have a choice. Now, one of the things, though, one of the things I think about why Toronto, there are two things I think that led to this happening. One is that Toronto has had and still does have a bit of a history as a place where specialized courts are seen as okay. So there were a number of specialized courts in Toronto. But the other thing is, and I'm going to come back to this, but the other thing is, it wasn't at all embarrassing. It wasn't at all difficult for judges in Toronto to say, you know, we don't really know the Aboriginal community here. It was okay for them to say that. It was okay to say we could use some help. That wasn't seen as a sign of weakness. It wasn't seen as anything other than we need a bit more information. And so I think it was easy because it was not threatening. Setting up a Gladu court was not threatening to anyone in the city, judicially or in the bar or anything. One of the first things that we thought we needed to do when the Gladu court was set up, and Paula Morato talked about this very extensively, we thought there needed to be a position created for someone to provide information to the courts, because you can't ask judges or you can't ask crowns and defense counsel who really don't often know how to talk to their clients. I mean, to be fair, if you go to, many of you are in law school. I don't know how many of you are taking criminal law courses. Certainly when I went to law school, we learned nothing about interviewing clients, really. We learned nothing about learning about their background. We learned nothing about how to handle the fact that someone you ask about their life tells you that they were sexually abused by their parents. We know nothing about that. So most lawyers have no ability, no inherent skill, no way of getting this information. Although we speak of lawyers and their clients as though the clients actually direct the lawyers, the reality is lawyers direct clients. That's certainly true with Aboriginal people, one of the findings of the AJI. Lawyers tell clients what to do. Sorry, I only got a minute here. You're going to do this. Pleading guilty. Is that okay? Yeah, fine, great. Okay. Have you ever seen a sentencing? You watch a sentencing. The offender, if they're pleading guilty, often says nothing. How do you plead? Your Honor, my client pleads guilty. Person hasn't said a word. Read out the facts of the case. Are those facts correct? Your Honor, those facts are substantially correct, whatever substantially correct means. Client says nothing. Client just sits there for the whole time. Goes through the system. You know nothing about the person, they don't say anything. So it's unrealistic it was unrealistic from our perspective to expect lawyers and crowns, some of whom, and I don't mean to be disparaging, many of whom are really committed and very hardworking, but to be able to provide information they were never able to provide. If they couldn't provide it in 1998, they ain't going to be able to provide it in 2000. So we thought we need to create a position for someone to provide this information to the court, and the idea was to create someone we called the Gladu caseworker. Separate from the court workers, a separate position that's dedicated just to do that. And that's what we did. We got a very small grant, we were able to hire someone, and it was a one-year deal. We worked on the assumption, well, we'll start it, and if it's worthwhile, if people think it's good, then we'll find ways to fund it. And it was worthwhile, and the positions became permanent. And now we have 5 Gladu writers, 2 in Toronto, 1 in the Brantford area, 1 in Kitchener-Waterloo, and 1 in Sarnia. And they write the Gladu reports that Paula spoke about. So that's sort of how things happened in Toronto, and things started to grow. They grew over time. More and more resources ended up going into the courts. Sometimes people say, you don't need a Gladu court. I hear this often. You don't need a Gladu court because Gladu applies across the country, which is true. It's also true that whenever an Aboriginal person is before a court, that court, at least for the moment that Aboriginal person is there, or those moments, is a Gladu court, because the judge has to apply Gladu. But that doesn't mean that Gladu is meaningfully being applied. And we can be pretty sure that's not happening because, as Deborah pointed out, rates of Aboriginal overrepresentation in Canada have continued to rise. They've continued to rise since Gladu. So it's not like massively we're doing things better. And one of the things that we found with the Gladu court is by having resources in one place, identifying particular issues. We were able to work with Aboriginal and non-Aboriginal organizations to provide more resources to the court. Things happen in that court that would not happen in other courts. Should they happen in other courts? Yes. Could they happen in other courts? Perhaps. But they happen in Gladu court because it's established and set up in a way that people, when they walk into that court, know that the expectations on them will be different. We've also found that we do Gladu reports for courts outside of Toronto, somewhere there is a Gladu court, most where there aren't. We find our Gladu reports make a particular difference. And they make a difference, again, because as was talked about in the first panel, we can't assume judges know things. We can't assume judges know what intergenerational trauma is or how it plays out. Why would they? We can't assume those things. So people have to get information. How are they going to get that information? The Gladu report is a way to get that information. So I want to talk for a couple minutes about, I'm going through my list of things. Deborah sent me a list of what to talk about. So, okay. And I'm going to take Shane Patterson's advice that I will speak from the heart, and I'm doing this, and I don't want to at all offend anyone, and I don't want to make anyone feel bad. And that's not what I'm trying to do. But I think we have to think about why change hasn't happened, right? I mean, if we all have the best will in the world, why do rates of overrepresentation keep going up? We're not doing something right. Or more precisely, we're probably doing something wrong. So why is that? And Sandra touched on this in her presentation. I'm lucky enough in my job to travel a lot. I get to come to Winnipeg in March, which is, I can't tell you how jealous people are, because in Toronto it's just sunny and 14. So I mean, people go, "You're going to Winnipeg?" Yeah. So, but one of the things I've discovered in my travels, and I will confine these comments to Ontario because I don't know enough about Manitoba, but one of the things I've discovered is as I travel, the further north I go, the stupider I get. It's remarkable. And you see, the thing is, I'm not aware that I'm getting stupider as I go north. But fortunately, there are people who will tell me that I'm getting stupider. And those people tend to be judges, crowns, and defense counsel. Because when I go, as I go further and further north, and I talk about Gladu, I get told, as I go further and further north, that I don't know what I'm talking about. Because I'm told by judges, crowns, and defense counsel, all three, repeatedly, we don't need Gladu here. We've always done Gladu. We don't need Gladu. We've always done Gladu. I know these people. I represented his father. Now I'm representing him. I sentenced his uncle. I sentenced his cousins. I'm sentencing him. I know these people. I know these communities. You stop coming here from Toronto and telling us how we're supposed to do things, because we don't need you. We do this stuff all the time. So that's how I know I'm stupid, because I'm told that. And I obviously have no way of, I can't challenge that, right? I can't say to someone, well, you're wrong. I don't know. In Thunder Bay or Kenora, I don't know those things. If someone says they know the community, I have to believe them. But when I travel, I don't just talk to judges, crowns, and defense counsel, as fascinating, as wonderful as those people are to talk to. I also talk to chiefs. I also talk to Aboriginal justice workers. I talk to community workers. And I ask them, I say, look, I just was talking to the judges and the crowns and the defense counsel, and they tell me that they understand your communities. They understand you and your communities because they've been coming in for a long time. So I want to ask you, do you think the people in the justice system understand your communities? And you know what? They don't. They don't think they understand them at all. So what we have in Ontario, and I will confine my comments to Ontario, what we have in Ontario, where we have significant Aboriginal populations in the courts, where the courts are largely Aboriginal, we have this massive disconnect. This massive disconnect where one set of people who have power think they know everything about the people they're sentencing who have no power, and the people who are being sentenced don't think they know anything about them. Now, I can't tell you who's right, because I don't know. But I know that's a very serious problem, because that's a really serious disconnect. And I know one of the biggest problems, and one of the things that I always have to remind myself, to try to know what I don't know. Recognize what I don't know. Because if I don't recognize what I don't know, I proceed as though I know things, when in fact I don't. And I think often what we're seeing are people thinking they know. I know this community, I know this person, and you know what? They don't. And why would they? How could they? How do you know someone? Court is not a particularly wonderfully social place where people hang out and tell the truth and talk. That's not what happens in court. You can see someone all the time in court. Doesn't mean you know anything about them. Most people in court comprise two pieces of paper. Excuse me. Thank you. Excuse me, your prop here. Thank you. Most people in court are two pieces of paper. Most Aboriginal people in court anyway. Two pieces of paper. This piece of paper is a synopsis of the offense, what they are alleged to have done. In Toronto, it's creatively written, misspelled often, grammatically incorrect, and substantially correct, whatever that means, which means there's stuff in it that's right and a bunch of stuff that isn't right. The other sheet of paper that sets out what an Aboriginal person is their prior criminal record. That's it. That's what it is. Your Honor, here's the offense. Your Honor, this person has these many offenses, this many failed to appear, this many failed to comply. You know, we have no choice. We have to send them to jail. You can, if you see someone 15 times, but all you ever get are those two pieces of paper, you won't know anything about them. You think you will, but you won't. Thank you. And on top of that, something was pointed out to me, and something else pointed out in the HAI. Criminal records often of Aboriginal and non-Aboriginal offenders look very different. Aboriginal offender and non-Aboriginal offender charged who have the same criminal history will have very different criminal records often. And one of the differences is, for whatever reason, Aboriginal people often, A, they plead, but B, things don't get taken off their record. There's a history, again, in Ontario, across Canada often, but certainly, again, I'll confine my comments to Ontario. Police tend to charge you with as much as they can. You know, the game is no one gets charged with one thing. It's almost impossible to be charged with one thing. So you're charged with 2, 3, 4, 5 things. And the idea is, over the course of the criminal justice system, however long or short that runs, negotiations will happen and things will come off the record, etc. So that at the time the person finally pleads, they'll plead to one or two things and a couple things will come off. But what has been pointed out to me by both Crown's and Defense Counsel who sit in Gladu Court, and those of you who are counsel, you might want to take a look at this. When they look at the criminal records of Aboriginal people, they often find very few charges withdrawn. And what happens then, if you don't have charges withdrawn, your criminal record builds up much more quickly. You appear to be a much more dangerous person. It's one of the systemic issues that Aboriginal people face in the criminal justice system. It's one of the things that helps move them more quickly along to well, we've got to go to jail, we have to go to more jail. So these are systemic issues that we have to find ways of getting around. And I don't know that Gladu Court is the answer, and I don't know that the way Gladu Court is done in Toronto is the way Gladu Court would be done elsewhere. There is a Gladu Court in Sarnia, Ontario as well. But I know that we have to start to think about doing things differently. We can't pretend that we're doing things right, because we're not. We can't pretend that we know things. One of the things that we always see whenever we do a Gladu report, is once the judges read that report, they go, I had no idea. And so I want to get back in the few minutes I have left to talk about what I think is a problem. And I don't know how to deal with this problem, and you'll know maybe because this is where you are. I think that many justice professionals see the Gladu decision as an attack. When the Supreme Court said that Aboriginal overrepresentation was a crisis in the Canadian criminal justice system, many judges, lawyers, and Crowns felt attacked. They felt it was like, it's my fault. I'm doing something wrong. And so if you go to judges and say, we want to put let's have a Gladu court, what some judges think you're saying is, What? You don't think I'm sentencing Aboriginal people right? And the whole set of cascading thoughts that come along with this. And I'm not restricting to judges. Crowns and Defense Counsel feel the same thing. They feel they're being challenged. They feel that you're saying you're not doing your job properly. And people don't like to hear that. Judges, defense counsel, everyone in the legal system, they work very hard. Most people in that system work very hard, and they try very hard. But they feel, and I don't know why, because I don't think Gladu was meant to be this way, but they feel that Gladu is an insult. And that's why when I go north, I'm told I'm stupid. Because what people hear, I think, and it may be my message, so I'm not leaving myself out of the equation, but when I say that Gladu means doing things differently, what people hear is, they don't hear we should do things differently. What they hear is, you're telling me I'm not doing things right. And that becomes a psychological issue. I'm not, who would have thought I'd be talking about psychological motivation of judges, crowns, and defense counsel? And far be it for me to really understand that in depth. But I do know that there's an opposition that's difficult to understand in otherwise than thinking of it that way. One of the things that we know works with Gladu Court, and one of the ways I think that maybe we can find ways to move forward, is that most judges who sit in Gladu Court find it really rewarding. Most judges who get Gladu reports really like them because it allows them to actually do something they want to do, which is make informed decisions. They actually get to know something about the person they're sentencing. They actually get to hear about a plan that might possibly work. They don't have to accept it, but they at least have that information. And the process, I think, in the Gladu courts is one that actually people enjoy. And if we can get over the fear, or if people can get over some of the fear and they can see the benefit, maybe we have to try and find a way to market Gladu courts more that way. But the benefit that what you get out of the process is feeling that you've done something. A judge once described sentencing, again, this is downtown Toronto, the sentencing courts as a sausage factory. Judges in Toronto at least get timed. They know how long an average sentencing takes. Sentencings are not supposed to take a long period of time. It's a busy place. 90% of cases that get resolved in Ontario in court get resolved by way of guilty plea. It's busy. We've got to move, got to keep moving them. And so that, at the end of that day, if you're sitting in a sentencing court, you don't go away feeling, oh great, what a wonderful day. Right? You want to, but you'd like to feel that. Everyone would like to feel that. And Gladu is a chance, I think, to give people that opportunity. Aboriginal Legal Services of Toronto a few years ago received an Ojibwe name, which I keep trying to pronounce. How many people here speak Ojibwe? Oh great, so you won't know then. And the name we got is Gakina Gwai Wabama Debwewin, which means all those who seek the truth. And that's not, to me, a description of what we do, as much as it's a direction to us. What we need to do is to seek the truth. It's what we need to do in the justice system. It's what I think we need to keep in mind as we look at this issue. What is it that we can do to seek the truth? The truth of the individuals who are before us. Let's not pretend that we know about people when we know nothing about them. Let's actually try and think about how we can seek the truth so we can do things differently and maybe actually arrive at justice. Thank you, Miigwech.